of the executive team reporting to the board and board committees.
And you were there until 2017?
2017 Jan, yes.
Yes. And thereafter?
Thereafter, I moved out of my employment to the legal practice, and I opened my legal practice effective 17 January 2017.
And it's still?
Yes, I'm still operating as such,
Okay.
effective 2017 to date.
And what kind of work do you do in this practice?
I'm passionate about civil litigation, which involves more of the family matters, administration of estate, trust, and the CPAs, where it involves the community project involving the land ownership, land claims by community members who want to pursue farming and agricultural matters within the specific areas. I also do the corporate work depending on the instruction, which mainly include the contracting, the governance structure, the legal opinion, the commercial transaction that involve the company law and corporate laws, depending on the instruction by the client.
Do you have any experience of adjudicating disputed claims?
Do I have experience
I
in?
see that adjudicating disputed claims.
Disputed claims?
Yes, I see that you remember or you were a member. It's not quite clear from your CV if you are still involved with this appeal authority.
Okay.
I'm trying to find out if you have any experience at all with adjudicating disputes between parties.
Okay.
You know, deciding cases.
Okay. So following my move from employment to the legal practice, effective 2017, I started moving into sitting at the boards and board committees. And part of that was including the appeals authority at the Ekurhuleni municipality.
Sorry, where?
So, Ekurhuleni municipality at the appeals authority. So, the Ekurhuleni municipality is structured in such a way that it has the tribunal and also the appeals authority. So, just to try and align it to the position where I'm coming for today, the municipality will have the tribunal where it allows the applicants to bring their application and deal with them as raw as they are from the applicants. And we at the appeals authority, we then look at the appeals that are lodged by the appellant, who are either originally the applicant in the initial application at the tribunal. Alternatively, they bring the matters directly to us, even though they did not start at the tribunal, because you find that in that instance, the decision or the directive by the authorized official in the municipality was not in line with the law, or they're disputing issues around legality or technical issues in terms of the SPLUMA, which is the Special Planning and Land Use Management Act. So as the appeals authority, we deal with those matters coming from the appellants, either directly from the officials or from the tribunal. So this is where I managed to deal with the disputed claims at the Ekurhuleni, and where I'm still a member to this date.
Since 2021, last year?
Yes, since February 2021.
Okay, so you make determinations, you give rulings, not so?
Pardon?
You give rulings after weighing the...
Yes, so how the proceedings are structured are that we have standard operating procedures that determine how we are going to operate, and I think they are more aligned to the tribunal rules in terms of the how and the when and the processes that need to be followed when lodging a dispute in this matter. And following that, we encourage the officials, the administrative support that receive the complaints, to ensure that they follow the checklist which deals with the compliance issues legally and technically, but also to ensure that the communication in terms of notifications, meeting the timelines, responses, and obtaining of the evidence and allowing the relevant parties to be involved in the hearing. Those processes need to be dealt with and ticked off so that by the time we have the appeals hearing, we have an effective and fruitful discussions that will lead to the decision making. So we try to, because what we did, when we started, we found out that the tribunal that was established before us was not properly constituted in terms of the Spluma Act. And in addition, because of the COVID, there was a gap of about over a year to 18 months when there was no tribunal and appeals authority at all. Actually, the appeals authority. So when we started, there was a huge gap, in terms of the backlog. There was a lot of work that we needed to deal with as backlog, but also we needed to make sure that we do the right thing, follow the processes, comply with all the rules and standard operating procedures, and make sure that we assist the process in dealing with the backlog and be able to deal with the new appeals going forward. So even though we started in Feb 2021, the amount of experience and the honing of skills within that short space of time was more in such a way that I believe that it allowed one to gather more experience within a short space of time. And especially because as the new appeals authority, we dedicated our resources in terms of time and ensuring that we deal with a lot of work within a reasonable time and without deviating from the appropriate rules and regulation in ensuring that the work that we do and the decisions that we make cannot be found wanting before the High Court. Because like the Water Tribunal, every decision that we make at the Appeals Authority can be challenged before the High Court by whoever party feeling prejudiced by the decision of the Appeals Authority.
I get the sense that you are very busy in this tribunal. On estimate, how many appeals would you say you have determined since you started last year?
We did about 25 to 30 plus minus of the matters that were including the backlog and the new matters that we deal with on an ongoing basis.
And how do you give your decisions? Do you give written rulings?
Pardon?
How do you give your decision in a matter?
Okay. So what we do, thank you for the question. So what we do, our process is that upon receiving the appeal, we make sure that the staff will also confirm that this matter desires the inspection in loco, so that when we deal with the matter, we've done the inspection as well. So for us to come to a well-informed decision, we make sure that if there's a need for inspection, we start at the inspection, we analyze the matters as raised by the parties, and we identify the material issues that we need to debate during the hearing. And going into the boardroom, we then start to deal with, we allow the parties to have appropriate time to ventilate the issues as they raised in their papers. We also allow them to talk to the papers that we have on record. We also allow them to bring information which may not have been provided beforehand. And I can see on the Water Tribunal that the similar approach is taken. Although we do encourage the parties to try by all means to provide information in advance so that we don't spend unnecessary long time when we could have gotten information on time. So considering the issues that we identified at the inspection, on the site, considering the record that we have gone through in the papers as lodged by both parties in lodging the appeal and responding to the appeal, considering the evidence and the attachment or annexures that are referenced to the appeal, but also the people who are necessary to give evidence during the hearing about the issues in dispute, we then come to a conclusion that having applied our mind to the process, to the issues at hand, to the technical issues, and also considering all the technical information that is necessary. For example, in this case, you need to look at water issues, electricity issues, sanitation, and everything involving the spatial planning and land use management. We look at all those and ensure that the responsible authorities from each department were involved and followed process in writing to ensure that the decision that we make is actually supported by the record of what they've done, the record of what they are presenting before us in the hearing. And once we've deliberated on all of that and we have gone through all the hearing and we've come to a conclusion that we are satisfied that all the parties were given appropriate time to present, to question, to answer, and to react to the issues raised before them, and in line with what is presented before us by way of records, we then take a moment after the hearing as the appeals authority independently to then pick up the issues that we found are critical, which will lead into the decision. So we summarize the discussion. We also direct our support staff to go and do the minutes based on the recording, because all the proceedings are recorded. So the recording of the discussions, the minutes, the summary of what we gathered as issues that we pick up during the preparation, all together, including the evidence that is produced and the evidence presented by the witnesses, becomes critical for us to make a decision. In terms of the law, we are given specific time to release the decision. And what we normally do, we encourage the support staff to release minutes within limited time, within a week of the hearing, so that we can validate our conclusion based on the recording. By the time we release the decision, we are comfortable that we cannot be found wanting when we make a decision that is in contradiction with the record of the minutes of the hearing.
And how is that decision conveyed to the parties?
How is?
How is it conveyed to the parties?
To the parties?
Yes. How are they told what your deliberations have come to?
Thank you. So what we do, we then
do you issue written rulings is what I'm trying to find out, Ms. Malebo.
Okay. So following our hearing, assuming this is the day of the hearing, we
Yes.
come to those conclusions. And those conclusions, because we discuss them in the presence of our support staff, it also assists them in capturing the minutes to make sure that they are in line with our discussion. So we get the minutes, we summarize the discussion, and following our deliberations on the draft minutes and the decision, we then agree that this is the final resolution, and that then the chair will sign off the resolution. Mm-hmm. Then following that, our resolution, in terms of the template that we use, we then release it in writing through our support staff to the relevant parties, including the parties that that the decision was made in their favor or against. So we release them either by email and by postage, and because it's a critical record that can be used even against the appeals authority at the High Court, we ensure that the communication must be done by email, but also posted to the relevant parties, and we need the proof of delivery to the relevant parties. And it takes about 30 days from the date of the hearing. And that is according to the bylaw that we utilize within the municipality. Thank you.
Are you familiar with the Water Act, the National Water Act, that is?
The National Water Act?
Yes.
Yes. Not necessarily in detail, but high level, yes, I can.
We don't expect you to memorize every provision. What is your understanding of the functions, the purpose and the functions of the Water Tribunal? In simple terms, what does it do? And what is its jurisdiction whilst you're at it?
The Water Tribunal is an independent body which is authorized by the National Water Act, to perform such functions as to allow the applications and or the appeals that are brought before it in terms of Section 148, which mainly deal with the contraventions or the directives that are made by the authorized officials within the within the Department of Water and Sanitation, which may be either prejudicing the relevant and affected parties, and depending on where the appeal is coming from, the Water Tribunal is expected to receive the appeal, but also ensure that in terms of the rules, the lodging of the appeals is lodged according to the timelines, it's lodged according to the prescribed rules, and is communicated appropriately to the relevant parties on time. And following that, the Water Tribunal will look at the appeal itself, analyze the legal issues raised, the technical issues raised, and following that, ensure that in terms of the timelines, the appeal sitting is arranged to allow the parties to present their case, which is in dispute, and also allow the respondent to the appeal to respond to the issues raised, and eventually allowing the appellant as well to react to the objections by the respondent. So the Water Tribunal is tasked at its authority with the powers to utilize their independent, objective, and diligent mind to listen appropriately to the issues at hand, to analyze the issues at hand, to validate the issues raised, and be able to question after hearing, after listening to the parties on the appeal, and be able to gather as much information. If there's evidence required, they are in a position to subpoena the evidence, to subpoena the people who are critical to provide and clarify issues at hand. And following that, the tribunal is then allowed to deliberate and discuss the issues at hand and come to a decision that will be in the interest of the parties, but also the interest of the public, because water issues are a matter of national interest. And because of the National Water Act, it becomes important for the Water Tribunal to apply its mind to the law, to apply its mind to the technical issues. Hence, even in the tribunal, it's important to have members with expertise on technical issues so that they can guide and assist on what is actually the issue on the ground. And also to make sure that the decisions that they make, they can be set as a precedent going forward. Because I believe that it's important to make those decisions that will address socioeconomic issues, will address the challenges that we have as a result of water scarcity and challenges that we have as a result of the climate changes, the soil erosion, the water scarcity. So it's important for the tribunal to apply its mind in all those factors before making those decisions, so that going forward, they can stand the test of time, the test of trial in court, and set as a good precedence going forward.
And what is its jurisdiction?
Pardon?
Its
the
area
jurisdiction?
of operation, yes.
The Water Tribunal has got jurisdiction to sit and have hearings at all provinces within the Republic of South Africa. So it can determine, based on the dispute, wherever it is, it can convene a sitting at that specific area.
And what is the role of the chairperson, the position you seek?
The role of the chairperson is actually to steer the proceedings. I believe that for the chairperson to be most effective, they need to utilize the administrative support effectively to guide and assist them in ensuring that issues that could unnecessarily delay the processes within the hearing, issues that could be dealt with in terms of compliance, ensuring that the notices are lodged on time, the relevant information is provided for, the subpoenas that need to be done are done upfront, proactively. And so there's a lot of engagement that need to be done between the administrative staff and the chairperson in ensuring that the meeting become effective. I'm saying that because I remember when we started at our appeals authority, we were the first professional body that was appointed independently and following the right procedure. And we found that we needed to create our own standard operating procedures to guide and assist the process. And we also found out that initially we had challenges because the managers who are critical in providing the right information to the admin staff in packaging our pack were almost ticking the box. They were not doing the right thing. And we then had to make sure that we liaise with the HOD of the city planning to ensure that there's consequence management for authorized officials who are defeating the ends of what we wanted to achieve. So they needed to take accountability. They needed to ensure that we are provided with all the relevant information. Wherever necessary, we'll sit with the authorized officials who are not necessarily party to the hearing so that they can give us an insight of what would have happened, so that when we get to the hearing, we get a better view of what would have transpired in this specific matter. And we do it in committee session. So the role of the chairperson, what I'm trying to say is to ensure that you make the proceedings to be seamless, agile, and effective. And in doing that is to ensure that the procedure of preparing for the hearing is transparent to all the parties who are lodging their applications and responding to the appeals so that they know the time requirements. Because what we also found out is that there are parties who are involved in the hearing, in the appeal, but they don't have and they cannot afford the legal representatives, especially people from previously disadvantaged groups. And even when they come or they appear, they cannot afford in many ways. So what we encouraged to management was that they need to make the communication to those people transparent and in very simple language, in their own language, so that by the time they come for the hearing, they are well equipped to state their story without fear and favor, without missing the critical issues. So we played a role in ensuring that the communication, the processes, the compliance checklist is such that it is transparent, and it will also go out to the parties to make sure that by the time we sit for the hearing, everything is in order. So as a result, I believe that it is the role of the chair to make sure that those governance structures are in place. The governance frameworks, including the code of conduct, code of ethics and conduct by all members, including the support staff, the conflict and the declaration of interest must be done in time, and wherever possible, if either one of the members is conflicted, they should be declaring on time and avoid getting documentation so that there's no bias in terms of circulating information and having a view on the matter. And the standard operating procedures, in addition to the code of conduct and declaration of interest, are very critical. It's also important to manage time, because having had all the governance structures and frameworks, the code of operating, the standard operating procedures, the rules in place, it's important to manage time to make sure that members attend the proceeding on time, they follow the proceedings, they allow the parties to deliberate on the issues. And also the other gap that we picked up is the opportunity where, in fact, the situation where you find that the parties tend to interject each other during the hearing without allowing the other to complete their presentation. So I believe that the chair has got a critical role in ensuring that of the hearing about their responsibilities, that they will be given specific time to present, and they must be allowed that whole time to present. It must be clear from the beginning, when is the other party allowed to respond or to react to the presentation, and so that allows for a smooth hearing proceeding, because the parties who present feel comfortable and feel, they feel that the process is fair, but they feel that they are able to make their full presentation without any interruption. And only after that, the questions can come up from the responding or the other parties and the members. And I also learned that one of the other roles of the chair is to ensure that you steer the discussion. There's a temptation of the parties, because often than not, they speak out of emotions, they are not happy with the decisions made. They get into emotional issues and issues that are not relevant to the hearing. Therefore, it becomes important to listen, but also redirect, so that within reasonable time, the party can focus on the critical issues at hand. And those discussions, as they become concise and direct to the dispute, they assist the authority to be able to make well-informed decision. So I believe the role of the chair starts from before the meeting, at the start of the meeting, during the meeting, and towards concluding the hearing, in ensuring that the outcome of the